The federal judge in Donald Trump's New York criminal case found the former president in contempt for a 10th time today. The decision is a response to the former president repeatedly violating his gag order. Judge Merchan is now threatening Trump with jail time if he continues this behavior. The former president is charged with 34 felony counts for allegedly falsifying business records to cover up an alleged affair ahead of the 2016 election. This is the 10th time Trump has been held in contempt for violating his gag order.
Hi, Lilia. So, yes, we're seeing a real escalation with these contempt findings. The judge is realizing that these $1,000 monetary fines are really not much of a deterrent for Donald Trump. We know that given his wealth, that's really just a very tiny fraction for him. So the judge is now saying that jail is on the table if this continues. And so far, we really haven't seen these gag order violations stopping Trump's rhetoric. If anything, he uses them to boost his fundraising. We've often seen...
Hello all, Adam is ready. Imagine being the most powerful person on earth and receiving a formal written warning from a judge that the next time you break a court order, you could be taken into custody. Not a hypothetical warning buried in legal language that requires interpretation. Not a subtle hint designed to be read between the lines.
I'm sure you've seen this. A judge has just threatened jail time if Trump continues to violate his gag order. This is another threat. I would have thought that helps Trump even more, doesn't it?
Oh, it does. Go ahead. Throw the leading candidate for the presidency of the United States in jail for using the First Amendment, speaking out loud. Are you kidding me? They are so unhinged on the left. These people have totally lost perspective on what's important in the United States of America. The president has a right to speak, and he should be able to exercise his First Amendment right whenever he wants.
A direct, explicit, written statement that jail is now on the table for a sitting president of the United States. That is not a scene from a political thriller. That is not speculative fiction about some future constitutional crisis. That is the actual documented reality Donald Trump is facing right now from Justice Juan Merchan.
Donald Trump was warned again on Monday that he could go to jail if he keeps violating the gag order in his hush-money criminal trial. New York Judge Juan M. Merchan, in his most explicit warning to date, said that it is clear the legal maximum fine allowed of $1,000 per violation isn't working. The judge said to Trump, "The last thing I want to do is put you in jail. You are the former president of the United States and possibly the next president as well. There are many reasons why incarceration is truly a last resort to me. To take that step would be disruptive to these proceedings. And the magnitude of such a decision," he said, "is not lost on me." However, Judge Merchan said that his duty is to the integrity of the trial and the integrity of justice. And he says that Trump has been undermining that with his repeated rhetoric about witnesses and about the jury in this case.
The judge overseeing his New York criminal case, after finding Trump in contempt of court 10 separate times, after fining him $1,000 for each violation, after documenting in writing that those fines are not working, that they are not deterring the behavior, that Trump keeps violating the gag order designed to protect jurors and court staff from his attacks. Merchan has now done something no judge has ever done before. He has put in writing that future violations could result in incarceration. His exact words, could result in incarceration. He called jail a last resort, but he made unmistakably clear that he will consider it if Trump continues ignoring court orders. 10 contempt findings, 10 fines, formal documented concerns about juror safety, and Trump kept going, kept attacking, kept testing the line. And now the judge has moved from fines that a billionaire can absorb without noticing to a direct and explicit warning that the next violation could mean handcuffs. That is not cable news hyperbole. That is a formal judicial warning recorded in court documents that will be part of the permanent legal record of this presidency forever. And the gap between Trump acting like he is completely untouchable and a judge writing that jail is on the table is one of the most extraordinary legal tensions in American history, and it is happening right now. Let's understand exactly what a gag order is and why violating it repeatedly is such a serious legal matter before we get into what the jail warning actually means. A gag order in a criminal case restricts what a defendant can publicly say about specific people connected to the proceedings: jurors, witnesses, court staff, families of the judge and prosecutors. The purpose is straightforward, and it is not about protecting powerful people from criticism. It is about protecting the integrity of the judicial process and the physical safety of ordinary citizens who participate in it. Jurors are private citizens. They did not choose to become public figures. They did not volunteer to have the most powerful man in the country attacking them on social media to tens of millions of followers. And when a defendant with that kind of platform and that kind of demonstrated ability to inspire aggressive action from supporters attacks jurors by name or implication, the safety risk is real. Mershon wrote that Trump's posts raised concerns for the safety of jurors and their loved ones. That is a judge describing a genuine physical safety threat to private citizens serving their civic duty, not a political disagreement, not a free speech question at the margins, a safety threat to ordinary Americans trying to serve on a jury. And Trump did it 10 times after being told to stop. 10 separate contempt findings, 10 fines. And he kept going. The line from Mershon's written ruling that the fines do not seem to be deterring him is perhaps the most important sentence in the entire legal picture for understanding why the jail warning is now on the table. It tells you exactly how the judge got to this point and why the escalation from fines to incarceration threats is legally coherent. The purpose of contempt sanctions is deterrence and compliance. You find someone to give them a financial incentive to stop the behavior that violates the court order. If the fines are working, the behavior stops and the matter is resolved. But Trump is worth billions of dollars. A $1,000 fine is not a deterrent for a billionaire. It is noise. It is less than a rounding error in his daily financial picture. After 10 violations and $10,000 fines, Mershon is documenting what is obvious. The financial penalty structure that would deter an ordinary person is completely ineffective against someone of Trump's wealth. And when financial deterrence fails, the only remaining tool in the court's contempt arsenal that carries meaningful weight is the threat that the next violation could result in something money cannot absorb: incarceration, jail, the loss of liberty that affects billionaires and ordinary people the same way because you cannot write a check to get out of a jail cell. This is the closest any judge has come to putting incarceration on the table for a president, and that context is essential for understanding the historic nature of what Mershon has done. American courts have been dealing with Trump's defiance of legal processes across multiple cases for years. Judges have issued warnings, imposed fines, expressed frustration, but explicitly putting incarceration on the table in writing for a sitting president over contempt violations is unprecedented in its directness. This is not a judge implying displeasure. This is a judge writing in a formal ruling that jail is a last resort he will consider. That specificity and formality matter enormously because they create a documented legal record that future actions can be measured against. If Trump violates the gag order again, Mershon now has his own written warning to point to. He cannot be accused of surprising Trump with a jail sanction he never threatened. The warning is in writing. The predicate for moving to the next level of sanction has been formally established, and Trump's choice now is whether to comply with the order he has violated 10 times already or push the line one more time and find out whether the judge means what he wrote. Let's really get into what this jail warning means in the broader context of Trump's legal situation. What would actually happen if a judge tried to jail a sitting president? Start with the pattern of behavior that produced this warning, because understanding the pattern is essential to understanding why the courts are now at this escalation point. Trump has been treating court orders as suggestions rather than binding legal obligations across multiple cases for years. He attacks judges on social media while those judges preside over his cases. He attacks prosecutors and their families. He attacks witnesses. He attacks jurors. He does all of it publicly and repeatedly after being explicitly ordered to stop. The 10 contempt findings are not 10 isolated incidents where Trump accidentally crossed a line he was not sure existed. They are 10 documented instances of a defendant who knew there was a court order restricting his conduct, understood what the order required, and chose to violate it anyway. That pattern of willful defiance is legally significant for the contempt sanctions it supports, but it is also strategically significant for what it reveals about Trump's calculation. He has concluded that the courts will not ultimately impose consequences severe enough to actually change his behavior, that the legal system will issue warnings and impose fines and express concern, but will not actually follow through with a sanction that would require him to meaningfully adjust his conduct. Merchan's jail warning is a direct response to that calculation. It is a judge saying explicitly that the calculation Trump is making is wrong, that there is a next level of consequence available, and that the next violation will bring it into active consideration. The question of what happens if a judge actually tries to jail a sitting president is one that legal scholars are genuinely divided on because there is no clear precedent that definitively resolves it. The Constitution does not explicitly address whether a sitting president can be arrested or jailed for contempt of court. The Justice Department has an Office of Legal Counsel opinion, an internal executive branch legal opinion saying a sitting president cannot be indicted while in office. But contempt of court is not an indictment. It is a civil or criminal sanction imposed by a court for violation of a court order. Whether the same constitutional immunity arguments that support the OLC indictment opinion extend to contempt sanctions is genuinely unsettled legal territory. The answer matters enormously because it determines whether Merchan's jail warning has real teeth or whether it is ultimately unenforceable against a sitting president who chooses to test it all the way. The most likely outcome, if Merchan actually moved to impose a jail sanction, would be an immediate emergency appeal to higher courts. Trump's lawyers would file within hours seeking a stay of any incarceration order. The appeals court would take it up on an emergency basis, and it would almost certainly reach the Supreme Court very quickly, at which point the court that already significantly expanded presidential immunity in its 2024 ruling would be asked to decide whether that immunity extends to protecting a sitting president from contempt sanctions imposed by a state court judge. That is a constitutional confrontation of the highest possible order, and it would create a legal and political crisis unlike anything the American system has experienced. The safety of jurors dimension is the moral core of this story that gets lost when coverage focuses primarily on the constitutional drama of president versus judge. The people whose safety Merchan documented concerns about in his written ruling are not political figures. They are not public officials who chose to enter public life and accepted the scrutiny and risk that comes with it. They are private citizens, ordinary Americans who were summoned for jury duty, showed up to serve their civic obligation, and found themselves being targeted by a sitting president on social media to an audience of tens of millions. The physical safety risk that creates for a private citizen is real and serious. We live in an era when political figures targeted on social media by people with large platforms receive credible threats, and in some cases actual violence from people inspired by those platforms. Jurors do not have Secret Service protection. They do not have security details. They go home to their neighborhoods and their families and their ordinary lives. And Trump's posts raised concerns for their safety according to the judge who reviewed them and documented that concern in writing. That is not a minor procedural violation being litigated at the margins of the legal system. That is a man using his power and platform to intimidate and endanger ordinary Americans performing a fundamental civic function. The court is trying to protect them, and Trump has violated the order designed to protect them 10 times and counting. The broader stress test dimension of this situation is what it reveals about whether the American legal system is actually capable of enforcing its rules on someone as powerful as a sitting president. That question matters most for the long-term health of American democracy, regardless of one's views on Trump specifically. The rule of law depends on the premise that the law applies to everyone, that no one is above it, that courts can enforce their orders against any party regardless of that party's wealth, power, or political position. That premise is exactly what is being tested by Trump's repeated contempt violations and the court's repeated failure so far to impose consequences sufficient to actually stop the behavior. If a sitting president can violate court orders 10 times and the only consequence is a series of $1,000 fines that he pays without changing his behavior, the message that sends about the enforceability of legal obligations on the most powerful person in the country is deeply corrosive to the premise that the rule of law applies equally to everyone. Merchan's jail warning is the court trying to reassert that premise, trying to establish that there is, in fact, a consequence serious enough to matter even for someone of Trump's power and wealth. Whether the legal system can actually follow through on that warning if Trump tests it is the most important legal question hanging over this entire situation. Here is exactly where we stand. Justice Merchan has found Trump in contempt 10 times for violating a gag order protecting jurors and court staff. He has fined him 10 times at $1,000 each. He has documented in writing that the fines are not deterring the behavior. He has documented real safety concerns for jurors and their families, and he has now put in writing that future violations could result in incarceration. The jail warning is on the record. The predicate for the next escalation has been formally established. Trump now faces a choice: comply with the order he has violated 10 times, or test the line one more time and trigger a constitutional confrontation over whether a sitting president can be jailed for contempt. That confrontation would reach the Supreme Court and create a legal and political crisis unlike anything in modern American history. Given that he has violated it 10 times already, nobody should be confident he will make the compliant choice. The judge has drawn the line. The question is whether Trump crosses it again, and everything that follows from that choice is going to be historic.